Okay, this is Scott Hearn, and we're going to review Senate Bill 1085, just printed yesterday in the Idaho Senate. Senate Bill 1085 is what is called a fetal heartbeat abortion ban, is technically what it's being called. It is being run by Senator Patty Ann Lodge and Representative Steve Harris. Let's go ahead and go through the bill and see if this thing is constitutional, see if it's something that we ought to support. So Chapter 87 is a new chapter being added to Idaho Code. So here's the bill right on the Idaho Legislature's website, legislature.idaho.gov. You can go to the current session information for 2021. There's the link, S1085. So it is being called the Fetal Heartbeat Preborn Child Protection Act. It has some definitions up here at the front. As usual, I pretty much just you should read definitions to understand what the bill is doing. I'm going to bypass it in my analysis of this bill. It is about a 4-page bill. We'll go ahead and go to the first major section besides definitions that it's adding to code. Page 1, line 36, 18-8702, legislative findings. Subsection 1, it says the life of each human being begins at fertilization. By the way, good word there, fertilization instead of conception. Fertilization is when the sperm meets the egg. Conception, defined in the medical literature, is when the fertilized egg implants. So it can actually be used to justify some abortion. So I'm glad to see that word fertilization there. It has some other findings as well. So talking about the fetal heartbeat, viability, etc. Then determination of fetal heartbeat. Section 188703, so right here you'll see I'm on page 2 of the bill. Any person who intends to perform or induce an abortion on a pregnant woman. Now the way I define abortion is not the ending of a pregnancy, but the intentional killing of a preborn human being. That is not the way this bill defines it. It is technically, if we go back up to the definition section, abortion means the use of any means to intentionally terminate the clinically diagnosable pregnancy. So really, when I focus on abortion, I talk about the intentional killing of a preborn human child. This one just talks about the intentional ending of a human pregnancy. So when we see the word abortion here, that's what we're talking about. So basically, it is requiring that the physician, any person who intends to perform or induce an abortion, must determine if there is the presence of any fetal heartbeat, except in the case of a medical emergency. And then what it says in the next section, 18-8704, is the person may not, you see these words here, perform an abortion on a pregnant woman when a fetal heartbeat has been detected, except in the case of a medical emergency. Okay. Let's stop there for just a moment. We're asking abortionists, people who are in the business of killing children for a living, to perform an ultrasound, which requires some medical expertise. And I will say this, that ultrasounds can be guided by the ultrasound technician to intentionally miss a fetal heartbeat, just so you know that as background. It's very easy to hide a fetal heartbeat. It's not like you just put this instrument over a woman's abdomen, over her uterus, over her womb, and then boom, there's the heartbeat. You actually have to use the instrument correctly in order to find a heartbeat, so it's easy to obfuscate. We're asking the killers to identify the fetal heartbeat, and then we're saying if there is one, they cannot perform an abortion. So my first objection to the bill, number one, is we're having abortionists do it, but let's get into a little bit more meat. If you look here at line 46 and line 47, I don't know why we keep doing this in our pro-life abortion regulations, but it says, or in the case of rape. So basically, if you've been raped or in the case of incest, I call these exceptions the exceptions that you can drive a truck through. This is why abortion continues to be legal in the state of Idaho after 48 years since Roe v. Wade and since the Idaho Legislature legalized it in Idaho Code. So we have this exception for rape. We have this exception for incest in this bill. That basically says even if the baby has a heartbeat, even if the abortionist has detected it, even if there were a ban on abortion for fetal heartbeat, never mind all that, go ahead and put the baby to death for the crime of its father in the case of rape or incest. Now, at least we say that a copy of the court determination of rape must be provided to the physician, or if there is no court determination, we say documentation that the rape or incest was reported to a law enforcement agency, or if it wasn't reported to a law enforcement agency, we say a licensed physician must certify in writing that in the physician's professional opinion, the woman was unable to report the rape or incest to a law enforcement agency. And the bottom line is we're throwing rape conceived babies under the bus. We're going to put them to death for the crime of their father. I would vote no on this bill for that reason alone, but there's worse problems in this bill. Okay, we're on page 3, section 18-8705. Here's the penalty. So let's say that you actually have a heartbeat ban in place in Idaho, which you're not going to. You're going to see that in a minute. But let's say you violate that. So you're the abortionist working at Planned Parenthood. You go ahead and decide to have your ultrasound tech find the heartbeat, and then you abort the baby anyway. You kill the baby. And guess what the potential penalty is? Any person licensed to practice medicine or registered as an intern or resident under Idaho code who violates by the way, this brings up a question, and if I were in the legislature, I'd raise my hand at this point. I'd say, are abortionists licensed to practice medicine or registered as an intern or resident in Idaho under Idaho code? That's a good question. I know Darren L. Wyrich, who is an abortionist in Boise. He is an obstetrician and gynecologist, so he's licensed to practice medicine. What about the guy who flies into the Meridian Planned Parenthood and butchers babies? Is he licensed as a physician, licensed to practice medicine in Idaho code? I don't know. But anyway, here's the penalty. So why is abortion wrong? Is it wrong because it's murder? Is it wrong because it's distasteful? Is it wrong because it's inconvenient? Why is it wrong? And then the penalty here is not a crime. It's not a crime. This is the amazing thing about this bill. So the penalty for violating this law, would be that the person who violates the provisions of this chapter here in line 15 by performing an abortion on a pregnant woman after the detection of any fetal heartbeat is subject to discipline pursuant to section 54-1814 Idaho Code. Let me tell you what that section is. There's a board of licensing for these practitioners, and there are various levels of professional discipline that they can exact. And so we're talking about professional discipline. Doesn't even have to include a revocation of your license. It's not a crime to violate this law. So if you kill this child after detection of a fetal heartbeat, even though that's a murder technically, even though there are men serving time in the Idaho Department of Corrections for killing a preborn child and doing a life sentence, if you do it as an abortionist, you may be subject to professional discipline, but certainly not even any crime whatsoever. Wow. I would object to the bill for this reason as well. Abortion's not murder. The preborn are not treated equally in law. If a husband kills his pregnant wife, he gets thrown into prison for the crime of homicide. If she hires someone to kill the child after detection of a fetal heartbeat, the assassin that she pays, might be subject to professional discipline, and that's it. Now, here's the real bad part of this bill, yet another one. But it's the worst part of the bill, in my opinion, because this is where we have all kinds of problems in Idaho law. So here we are on page 3. We have the new section 18-8706, lines 18 through 23. And what it says is that this bill, this chapter, so this entire law here, the heartbeat abortion ban, takes effect immediately upon the issuance of the mandate in any United States appellate court case in which the appellate court upholds a restriction or ban on abortion for a preborn child because a detectable heartbeat is present on the grounds that such a restriction or ban does not violate the United States Constitution. This is what we call a trigger. So this is how Idaho will not be sued if this bill passes this year, S1085, and is signed by the governor, like we signed into law last year. The governor signed S1385, which contained a similar trigger. That one was a trigger based on a Supreme Court opinion. This one says that we have these appeals courts. So the way the United States works, here's our map right here. Idaho's right here in the Ninth Circuit Court of Appeals. These are the U.S. federal courts, okay? And these are they're organized into appellate circuits. So when you sue in Idaho, you go to the District Court of Idaho. It's the U.S. federal court for the District of Idaho. And then if you lose there and you appeal, it goes to the Ninth Circuit Court of Appeals. Well, what this bill is saying is that it will only go into effect if some heartbeat ban in any state, anywhere, gets upheld as constitutional by the 1st, 2nd, 3rd, 4th, 5th, 6th, 7th, 8th, or any of these circuits. If any of them uphold one of these bans, then this bill will go into effect. Here's the problem. These bills are not brand new. The first ones passed in 2013 in North Dakota and Arkansas. Arkansas is right here. North Dakota is right here. Those were immediately enjoined by a U.S. District Court. So sure enough, the abortionist or the woman sued back then in 2013, and the 8th Circuit Court of Appeals blocked it. We have a heartbeat abortion ban in Mississippi. It was blocked by the 5th Circuit Court of Appeals. Georgia has a heartbeat abortion ban, which is permanently blocked by the U.S. District Court and is up for review by the 11th Circuit. Ohio has an abortion ban based on fetal heartbeat that was blocked by the U.S. District Court, may be up for appeal by the 6th Circuit. And there's no inclination that any of these circuits are going to go that way. Let me explain. Here's last summer's United States Supreme Court decision. This was the 40th court opinion. It may have been the 38th. I have to go check. But it was the 38th or 40th United States Supreme Court opinion. This was written by Chief Justice Roberts. Here's what he wrote. He said that Casey, this was a 1992 case, one of the 40 opinions of the United States Supreme Court, reaffirmed the most central principle of Roe v. Wade, a woman's right to terminate her pregnancy before viability. Viability is basically, they used a trimester framework. It's 24 weeks is what the federal courts say. At 24 weeks, a baby could survive outside the womb. That's viability. And she has a right to kill her child before 24 weeks. And these heartbeat abortion bans are before 24 weeks. So this is the United States Supreme Court last summer. Well, all of the appeals courts refer to this United States Supreme Court jurisprudence. This is the jurisprudence called stare decisis. Roberts here lectures on stare decisis from this court opinion from last summer. Only 8 months old at this point. From the United States Supreme Court, June Medical Services versus Russo. It was issued June 29th of 2020. And basically in here, he reiterates the Casey decision and the Roe v. Wade decision that a woman has a right. Here it is right here. The upshot of Casey, that was the 1992 case of Planned Parenthood versus Casey, is clear. The several restrictions that did not impose a substantial obstacle were constitutional, while any restriction that does impose a substantial obstacle was unconstitutional. What they're saying is the states may not impose any substantial obstacle on a woman who wants to kill her child by abortion before 24 weeks gestation. While heartbeat abortion ban is clearly a substantial obstacle. They're saying that you can't get one at 6 weeks, 7 weeks, 9 weeks. That is a substantial obstacle, and that's why the courts continue to say that these things are unconstitutional. They're unconstitutional according to the United States Supreme Court and according to these appeals, federal appeals circuits, which basically obey the United States Supreme Court. Now, here's one thing to know. The ban that was upheld on the North Dakota heartbeat bill and the ban that was upheld on the Arkansas heartbeat bill were appealed to the United States Supreme Court, and they were both rejected by the United States Supreme Court. This is why I continue to say there is no path forward to ending the abortion holocaust if we are going to depend on the federal courts. The federal courts are part of the problem. The other part of the problem is there are probably state legislators and a lot of people in our state of Idaho. If you just read the news on this particular bill, S1085, there's a lot of people who support a woman's so-called right to get an abortion. And until we're willing to call it murder, and until we're willing to exert state sovereignty, our state authority in the United States Constitution to outlaw murder, and we establish equal justice in the law, and we assert our right as a state to defy the federal government. That's called dual federalism. And until we assert the right of the legislature to pass a just murder law, despite the judiciary's opinion, that's called a balance of power between the legislature and the judiciary. See, the judiciary was not designed to rule over the state of Idaho. The legislature makes law, and the judiciary gets it wrong. A woman does not have a right under the 5th or 14th Amendment of the United States Constitution to kill a preborn child. She just doesn't. And so we have to assert the right of the baby to live. That's another person. It's not the mother. The baby is a separate person. Here's another problem I have with the bill, but the bill has so many problems anyway, but it's the next section on page 3, 188707. Any woman on whom an abortion is performed in violation of this chapter, she's not held accountable. Instead, she may recover in a civil action all damages available to her under Idaho law from the person or persons who, in knowing or reckless violation of this bill, engaged in such violations. Well, wait a minute, hold on. So she hires an abortionist to kill her child. He performs fetal ultrasound, finds a heartbeat, kills the child anyway, and now all along we assume she knows exactly what's going on. And now she's able to file a civil suit against him? I mean, this is just crazy. She's the one who hired the assassin. We don't think she has culpability? Of course she has culpability, but it doesn't do her any good. It doesn't do mothers any good to teach that they don't have culpability for killing their own children. They have culpability for killing their 5-year-old, right? They have culpability for killing their 1-year-old born child. Well, why don't we want to hold them culpable for killing the child that's in their womb, that they should actually care the most about to take care of, that they actually have the highest duty, the highest responsibility, and are in the best position to protect that preborn child. But we don't hold them accountable. Well, that's S1085. S1085. So the exceptions for rape on page 3, we should reject it. The effective date that it's not going to go, this is called judicial supremacy on page 3, lines 18 through 23. It won't go into effect unless an appeals court upholds some other state's heartbeat abortion ban. Planned Parenthood isn't even going to sue us over this because it won't be in effect, because there is no appellate court that's upheld one of these bans. And we've got to get over this false hope that the United States Supreme Court or the federal courts or even the state courts are going to uphold an abortion ban. They're not. This has been 50 years, 48 years since Roe v. Wade, and dozens of court decisions at the federal level, plus actually quite a few state cases. In fact, the Iowa heartbeat abortion ban, the lawsuit against that, so they have a heartbeat abortion ban. The plaintiffs in that case filed in the Iowa state courts, not even the U.S. District Court for Iowa. And the state court upheld the heartbeat bill as being unconstitutional. I mean, if someone filed in the Idaho state courts, I bet the Idaho Supreme Court would look at the U.S. Supreme Court and they would say that abortion is a constitutional right for a mother. That's where we are. And so if you're going to ban abortion, you have to start talking about what it is. It's murder. Mothers are accountable. The courts are playing the tyrant, and the legislature writes laws and has the right to outlaw abortion as murder in its state, regardless of the judicial branch's opinion and regardless of the federal judicial branch's opinion. And that's the only path forward. And until we do that, we're going to have legal abortion called child sacrifice with us forever. If you're a legislator, please vote no against this bill. It's got so many problems. Let's not train in judicial supremacy. Let's not train that abortion is less than murder. All right, thanks for paying attention to this video. Spread the word. Share with your legislators. You can go to legislature.idaho.gov, look up who's your legislator, and ask them to oppose, here it is, S1085, right here, S1085. Ask them to oppose this bill, Senate Bill 1085 by Patty Ann Lodge and Steve Harris in the House of Representatives. It will go before a House committee next. It'll be Senate State Affairs is where it'll get a hearing next.